And welcome, ladies and gentlemen. This is Truth on the Tracks. I'm Brandon Turbeville. For those of you who are just tuning in, I just wanted to let you know that you can catch Truth on the Tracks here every week, Monday night, 9 p.m. Eastern Standard Time, and Friday night, 9 p.m. Eastern Standard Time here on ucy.tv. You can also go to the show's page specifically, which is ucy.tv/TT for Truth on the Tracks. For the new listeners, if you don't already know, I am a staff writer for Activist Post over at activistpost.com. You can keep up with some of my work there as it comes out. On the home page, you can also go to the Contributors tab, click on that tab, and find some of my work as well. If you're interested in just keeping up with my work specifically, then you can go to brandonturbeville.blogspot.com, which is where I repost all of my articles, all of my interviews, and the archived videos of Truth on the Tracks. What I try to do on this show is I try to go over some of the news that I've been paying attention to, some of the current events, some of the research, in hopes that it'll be of some interest to you, and in hopes that you might be able to take the information and spread it out there a little further. Tonight, however, I'm going to do something a little bit different than what I've done on the previous shows, as we have a guest. We have Katerina Jaleva with us here tonight. Some of you who have listened to the previous shows will know who she is, as I've done 3 articles about her. Katerina is the mother from Utah who has had her son stolen from her by a corrupt CPS, DCFS system, as well as a family court system in Utah. She's here to tell us a little bit about her case and what you can do to help, and maybe what you should pay attention to in your own cases. And we'll try to put up some of the articles, some of the relevant information here on ucy.tv/TT for Truth on the Tracks, as well as some more relevant information there. So, Katerina, welcome to Truth on the Tracks.
Thank you, Brandon. Thank you. Good to be with you.
So why don't you give us a quick rundown of your situation? We'll kind of take it from the top for the listeners who might have joined us for the first time or might not have heard of your case before or know what's going on with you. Why don't you take a minute to tell us what's actually going on?
What's going on is a battle that I've been fighting for the past year. It's been exactly 1 year on the mark, actually, since my son was taken away by, as you mentioned, by the DCFS system here and their agents, and he is still gone as of today. So I've been fighting in court. I've been fighting a corrupt guardian ad litem, and it's been a very uphill battle for me this whole time. Everything started last year this time when I was served with a protective order. Now, this is an ex parte protective order. Anybody, for any crazy reason, can obtain a protective order, and it gets signed. The ex parte part means that you do not need to notify the other party. They don't have the chance to defend themselves, to present any evidence or any defense, anything like that. This protective order is just signed, usually at the juvenile court, and then 1 day later you get served as if you're a criminal and as if you've done something wrong, without a chance for you to present your evidence and your defense. Then they give you, I think, about a month. They give you 3 to 4 weeks to go to court. They set up a court date. But however, during this 3 or 4 weeks, you are presumed guilty. So if the protective order, say, like in my case, had to do with my son is immediately taken away on the presumption that I have done something wrong. So this is how everything began, with a protective order, with a bunch of false allegations, which later I can tell you all about that, but those allegations were refuted by the investigators in my case. Regardless of that, my son was taken after the protective order, and I didn't see him for a month, then after my ex-husband didn't show up to the hearing, and my son came home for 1 day, for one evening actually, and he was again the next day taken by armed police from my house, from my arms, because my ex-husband refiled the ex parte protective order again, and it was again signed on the same false allegations, and my son was taken away again. And I didn't see him for a very long time. I actually didn't see him for 7 months almost. Yeah. And then I saw him one time for 1 hour in July. That was 7 months later. Many court dates and several investigations by DCFS. They came up with negative result, which means that the allegations of child abuse, because this is what the whole thing was all about. I was accused. I'm sorry?
Just to interrupt, just so the listeners know, DCFS stands for the Department of Child and Family Services. It's
That's
essentially
right.
the same thing as CPS. It's only the Utah version.
Yes, CPS, DCFS, yeah, just family services. And then the several investigations were conducted, both by detectives and by the Department of Child Services. They looked into the allegations. They conducted complete interviews, investigations, everything, and that happened 3 times. And all 3 times, the result was that the allegations were unsubstantiated. However, I still don't have my son, and this is how the system works. The longer they can protract everything, the more money they can get from the taxpayers and from the parents, from the lawyers, from the clerks. The guardian ad litem get paid. It's a very corrupt system, very, very corrupt. And actually, they claim that they have the best interest of the children, but nothing can be further from the truth. The children don't even come into play. It's all money, and it's all games, and it's all underhanded tactics and such.
Well, speaking of the guardian ad litem, you've had quite the time with your guardian ad litem, Amber Reuter, or the former guardian ad litem, Amber Reuter.
That's right. Yeah.
For the listeners again who might not understand what the guardian ad litem is, it's essentially an agent of the court who is supposed to act as representation for either a minor or someone who's not mentally capable of acting in their own self-interest. So whenever a minor child is involved in a situation like this, they give the child a guardian ad litem. Unfortunately for you and for many others, that guardian ad litem, well, I should mention that it never should have happened to begin with, but your guardian ad litem was Amber Reuter, and she tends to do whatever she wants, for lack of better terms. Could you tell us a little bit about your year-long saga with Amber Reuter?
Yes, she was the main antagonist during the whole time. This guardian ad litem, what they really are is they're just another lawyer. They are an attorney for the child, However, they act under the color of law, and they abuse their position. And I did not know that before. I know it now. But the judges and the courts they treat them with such deference. Their opinion, and all it is just another attorney's opinion, goes above the detective's opinion, above the investigators. So their word is the gospel, basically. So you can imagine how some crooked people that happen to be in those positions of power can abuse that power, which is exactly what happened to me. My guardian ad litem, Amber Reuter, did everything to sabotage my efforts to see my son through therapy, which was ordered by the judge and by the court. She wantonly defied the court orders, and what she also did was she accused me of being a bad mother because I had abandoned my son and because I hadn't contacted him for 7 months. Mind you, I was forbidden, I was barred from contacting him in any way. No telephone contact, nothing, because I had this protective order, that was signed against me with no evidence, of course. So, had I tried to contact my son, I would have gone to jail for breaking the protective order. But this doesn't matter. Amber Ruder said I'm a bad mother because I didn't contact my son. Do you see how schizophrenic this is? When they couldn't find any evidence of abuse whatsoever, time after time after time, she just started making up stuff. Just like I told you that I had abandoned my son when I was prevented from contacting him at all. And finally, when I was able, after spending thousands and thousands of dollars on therapy, making appointments being missed for no good reasons, I finally was able to see my son for 1 hour. That cost me a couple $1,000s. So I saw him for 1 hour, and he was very, very happy. He told me he loves me. He was very, very excited. And right after that, I was supposed to see him again the next week and again the next week. However, my son didn't show up anymore because Amber Ruder had given him, and when I say my son, he's not acting on his behalf. He's just a little 8-9-year-old boy. Everything, all the strings are being pulled by my ex-husband, my son's father, and Amber Ruder. So she gave them permission not to come to court-ordered therapy, and that was that.
Right. That's something else that's to be pointed out here is that the underhandedness of Amber Ruder and the way this whole situation was handled on their part was not necessarily something that was hidden. This was out in the open.
No.
The judge would order Ruder to facilitate the therapy.
That's right.
It was actually her responsibility to set up appointments and make sure that everybody met those appointments. But she actually sent an email to you that plainly stated that I cannot and will not do this for you. I've seen the email. Right? So
absolutely.
It was just completely out in the open. When the judge would make orders, Ruder would simply ignore those orders and go on about her own agenda.
Yes, that's right. And her agenda is to separate children from their loving parents and to get a bonus for it. The truth didn't make any difference. The fact that you are being exonerated didn't make any difference. If there was nothing there, she would just make it up. She would just start making up stuff and perjure herself in court. Perjure herself.
She did.
Yes, she did, over and over and over. Yes. I tried to get this rogue guardian ad litem dismissed a couple times, unsuccessfully, because what they call them is officers of the court, even though all they are is they're just another attorney, right? However, they're government agents, also called officers of the court, and they act with immunity. You cannot sue them in their capacity of guardian ad litems. You cannot do that. So that just simply opens the door for for a lot of corruption, for a lot of abuse of their position, under, like I said earlier, under the color of law, which is illegal. All of this behavior is illegal, and we are completely powerless to hold them accountable.
Right. Well, again, and going back to how open they were, and just completely ignoring the judge's orders when it came down to therapy for you and your son, a conjoint therapy, which again I point out should never have happened to begin with. This was after 2 protective orders, as far as I know, if I'm not mistaken. 2 protective orders were found baseless, and that there was no evidence for sexual abuse. You still had to go to conjoint therapy and pay for that therapy nonetheless. And after the first appointment with the therapist, Amber Reuter decided that your son didn't have to see you, and that it was up to everyone essentially except the court and you as to whether or not the therapy could continue. This was a violation of the court order, by the way.
Yeah, absolutely. It was a violation. And the reason the whole therapy was ordered was because while the legal procedures were going on, the way for me to see my son while they completely clear and close the whole case was for me to see him through therapy. You know, as they said, for his protection, even though there's, like you said, there's nothing to protect him from, but this is just the law that they have in place. While the court procedures are going on, I get to see my son through therapy. And then he comes home after the court case is completely over. What happened actually was they kept dragging it on and extending the dates and changing the dates and giving me pre-trial after pre-trial, and they were all a couple months apart, 2 or 3 months apart, just dragging the whole thing, you know. I don't know, hoping that I would run out of money, which I did, hoping that I would give up, which I never will. So this is why I was supposed to see my son through therapy. However, just like you said, Amber Reuter decided that she doesn't want my son on the record in front of somebody else to be telling me that he misses me, that he loves me, that he wants to give me a hug, because her whole agenda was to make me look like I'm guilty. She kept referring to me as the perpetrator. Even though I was clear time after time, she kept calling me the perpetrator. What the other thing she did, and this was in court on the record, in front of the judge, she wanted me to apologize for what I have done. She also to apologize, see, to basically to trap me into admitting that I've done something I haven't done. This is the kind of people you're dealing with, and these are the kind of tactics that they use. And this is not an isolated case, none whatsoever.
No, and the treachery of their legal team went much further than that, actually. After they had led you for all the money that you couldn't afford an attorney to represent you anymore, and you had to fall back on representing yourself, which is no easy task considering the way legal documents are written and the way the court system is designed. But after you had to fall back on representing yourself, there were still underhanded tactics, like the fact that you were getting documents that were supposed to go to you as you were representing yourself, that they were actually going to the office of your previous attorney.
That's right.
And you had no idea that the documents were there, right?
No. You don't. Once you no longer use the services of a certain attorney, they don't have to tell you any documentation or any correspondence that's being sent to them on your behalf, because they're not getting paid, right? You know, attorneys don't have much. Yeah.
And why would they? I mean, why would they
exactly.
go to the courtesy of mailing a letter?
What also happens, however, is if you don't know that you're supposed to be in court, which happened to me one time, I barely by accident found out that I'm supposed to be in court, because just like we were saying, the documents were sent to a different attorney, not to me. I was supposed to be in court in 2 days, you know, and if I found out by accident, I was not prepared, but I was very lucky, you know, to even have found out. So I went, and again, I pointed out that I'm not prepared, I wasn't made aware, and just the same thing continued, you know. Months after that, they kept doing the same thing, so I had to call the court every single day to find out what has been filed. because if you happen to miss the deadline or the date, if you don't show up in court or if you don't submit your papers on time, they automatically rule against you. So that's one way for me to lose if I just don't know, which they tried for months at a time. Yep.
Right, and even with your ex-husband's attorney, Jerry Rainier, when they filed a motion to terminate your parental rights.
Yes, that's right.
They filed a motion to amend the petition, right? So this is essentially a motion to terminate parental rights, but they have to amend that motion to do so. Well, they filed. I'm going to let you elaborate on this, but they filed the petition filed the motion to amend the petition on, I think it was March the 1st. And then on the same day, they filed the amended petition, essentially flaunting the decision of the court, saying, this is our petition to amend. We know you're going to rubber stamp it. And we're so confident that we're going to just file our own document.
Yep, that's exactly what happened. Because when you file an amended anything, first of all, along with that, you file a paper asking permission for the court to grant you. You asking the court to grant you permission to amend a petition that you've already filed. However, they filed everything all at the same time, just thinking the judges is going to rubber stamp it, just like you said. Just the rules don't apply to them, and this is how the whole legal team had this kind of mentality throughout the whole time. Nothing was honest. They disregarded the DCFS reports that basically were saying that their allegations are false, unsupported, unsubstantiated, and basically you cannot file a petition to terminate somebody's parental rights based on nothing. You have to have clear and convincing evidences, which is one step higher than the preponderance of evidence, which is the lowest evidentiary standard, the one they use for rubber stamping protective orders. So termination of parental rights is actually a very serious thing. They're talking about your constitutional right to parenthood and motherhood, and their evidentiary standard is much higher. And these people had nothing. Not only did they have nothing, they were completely proven wrong 3 times. What kept them going was Amber Ruder, the infamous Amber Ruder. Yeah,
she's certainly famous for the way she handled these cases. But even the judge stated that they did not have this clear and convincing evidence at the trial. But for any of the listeners who are listening in now and have maybe had any dealings with the court system, if you can imagine filing documents, you already know if you've had to deal with the court that you have to grovel to these people.
That's right.
In general, whenever you appear, but if you file documents on the assumption that the court will rubber stamp your petition to amend or whatever your petition is, then if you haven't approached the court system in that way, you should try it sometime and see how far it will get you. It won't get you very far unless, of course, you're certain individuals like Amber Ruder and like Jerry Rainier. They've been very successful at it, or at least they were for some time. But I want to go back to the therapy sessions here for a minute, Katerina, because you had a total of 2 therapy sessions, and one was at the initial date, as it should be, and your son was quite happy to see you. And then there was some stalling on the part of your ex-husband and Ruder.
That's right.
Something came up, how convenient that something came up, and it took
always, every time.
It took over a week for those guys to get together. and essentially they never rescheduled. They just made to the appointment that would have been the third appointment. And lo and behold, at the third appointment, there was a marked shift in your son's personality. And if you want to tell us a little bit about that, we've got a couple minutes left in this segment.
Well, basically what happened was at the very first appointment, he was very happy. He was ecstatic. He was hugging me. He told me how much he loves me. And the next time, he was completely changed. He was not himself. He was, and he did not want to talk to me. He did not want to see me. And he told the therapist that he has had permission from his guardian ad litem, from his attorney, Amber Ruder, to not come to see me anymore if he didn't want to. So the therapist and my son went and talked for a few minutes, and then she wrote a report. That therapist wrote a report of exactly what happened. And what she said in her report to the court was that my son did not act like a 9-year-old boy. He didn't talk like a 9-year-old boy. Basically, he was speaking somebody else's words. That is probably Amber Ruder's and my ex-husband, you know.
That he was coached.
And
right.
He was coached what to say. That's right. That's exactly right. Yes.
Yeah, I actually have an excerpt here from the letters of the court that Dr. Stringham wrote, and Dr. Stringham is the clinical psychologist that was supposed to undertake the therapy with Katerina and her son. And the letter reads, I'm going to read this excerpt here. His responses during the second visitation raises serious concerns regarding him receiving adult influence. Although it would not be unusual for a child who is reconciling with a parent under similar circumstances to be again guarded at the beginning of another contact, a number of his comments, both during his one-on-one disclosure to me and during the time with his mother, did not sound like the typical language of a child his age. It also appears from his response to receiving the video that he had spoken with someone about her plan to bring the present. Now, that was a quote from Dr. Stringham's letter, and that the present was just a little video that the two of you had that the two of you had talked about on the first therapy session, and he was quite happy to receive. Yeah. He was looking forward to it.
But and then he refused. Yeah.
Right.
Then he did not want the present. He didn't want. He didn't want anything to do with the DVD or anything like that. Now mind you, no one, the adults are not supposed to talk to my son about the court case. And this is what the therapist said when she, in her report, this is what she meant, that he has been talking to someone. And they're not supposed to be talking to a 9-year-old about the court case. He's supposed to be as sheltered as possible. So right then and there, it's obvious that he's had a talking to, and I'm not sure whether he's been threatened. I'm not sure if it's just simply coaching and brainwashing, but something happened to my son for him to change so dramatically.
That much was clear. Yeah, and again, that was a letter from the court-appointed therapist. This is not someone outside of the court system. So
yes, a professor.
Right.
And she has a long experience with the juvenile court. You know, they use that same clinical psychologist for many cases. However, Amber Ruder, after she read the report, she did not like what she heard in the report, what was written, basically that my son has been coached, which was what I had maintained from the very beginning. And after Amber Ruder got her hands on the report, she said, this psychologist is incompetent. We need to replace her. We need a new psychologist. She's giving the wrong type of therapy. This is the wrong type of report. Basically, she backpedaled from extolling the psychologist and how smart she was, and she was this professor and this and that. And after Amber Ruder read the report, he said, no, we do not need this psychologist, and she suggested her own pal to be the new one.
Yeah, she did a complete about face on that.
Oh, yeah.
Hold that thought, Katerina. We're going to take a break, and we'll be right back after this on the other side.
We're ending the lie at UCY.TV. For the people, by the people.
I'm Madison Rupert, host of End the Lie Radio here on UCY.TV every Monday at 7 p.m. Pacific and 10 p.m. Eastern. Tune in and listen to some wonderful programming.
And we're back, ladies and gentlemen. This is Truth on the Tracks. I'm Brandon Turbeville. Tonight we have a guest with us, Katerina Jaleva. Some of you might be familiar with her. She is the mother from Utah who's had her son stolen from her by a corrupt DCFS, CPS family court system. Now, just to point out, actually, I want to go back to Katerina now to finish the point that she was making before we go any further, that she was making at the previous segment about how guardian ad litem Amber Reuter did a complete turnabout when it came to the credibility of the therapist. Before the therapist wrote a letter to the court and made her determination that Katerina's son had been coached by another adult to make these claims, then Dr. Stringham was the epitome of credibility. She was great at her job, and all of a sudden, when she found out that Dr. Stringham recognized coaching, then suddenly Dr. Stringham was no longer credible. Suddenly she was incompetent, and she was not providing the right kind of therapy, and the therapy had to be changed entirely. For Amber Reuter's decisions on what type of therapy should be given. So, Katerina, do you want to continue on that?
Yes, absolutely. The Amber Reuter, on the record, just said those things in front of the judge, and then she, in a written form, she submitted all that to myself, suggesting her own psychologist recommended by her, the one that would actually write a report that would probably say that I'm guilty, of abusing my child. This was the whole point. She was fishing for the result that she wanted, because this Amber Reuter had maintained throughout the whole time that I have abused my son, despite the fact that we had 3 investigations by a couple detectives, and 3 Child Protective Service investigators. Amber Reuter, and she alone, maintained that I must have abused my son if she says so. Yes, this is what she did.
Right. The evidence for the abuse, of course, was not the psychologist's evaluations or the special sex abuse unit investigations or the detective's investigations or anybody's investigations. The reason that the proof for the abuse was that Amber Reuter said so.
That's right.
Yes. Court-appointed guardian ad litem said so. So it must be true. Now, one of the things about your case, Katerina, that a lot of people might be surprised about is that when I mentioned the CPS system, the DCFS system, it's the same system. It's just the difference of the name of the Utah version of CPS. What many people might be surprised about is it's not just the CPS system. In this case, they even the CPS workers, the DCFS workers, are clear that there is no evidence for abuse.
That's right.
In most people's case, the CPS goes right along with it, and there's really nothing that they can do. But in your case, it's a little different because the detective, the Springville Police Department detective, Jeff Ellsworth, he has investigated this case at least twice. And he says that there's no evidence.
No.
Emmy Drews, who is the DCFS worker, she's actually the part of DCFS.
Yes.
She's reviewed the case. Same thing. There's no evidence. Then there was Carly Eccles, who was the special sex abuse investigator. Same thing. No evidence. And then Dr. Stringham, who's taken a look at this case several times and actually has done therapy with the child and with you and the child. Dr. Stringham even says that not only is there no evidence for abuse, there's evidence that the child was coached by other adults to make the claims of abuse.
That's right.
Yet you are still without your son. You still haven't gotten your son back, and I don't know if you want to comment on that, but you have so many people within the system who are usually chomping at the bit to make declarations of abuse. But these individuals, even within the system, the police department, the mental health department, the special sex abuse units, and the DCFS, they all reviewed the case, and they've all determined that there's no evidence for abuse. So if individuals within this system can say that there's no abuse, it obviously has to be quite clear that there's no evidence for it here.
Absolutely. It is clear to everybody. I'm sure it is clear even to Amber. However, she just wanted to convince everybody that the sky was purple if she said the sky was purple. And it was, a lot of the time, I was floored. I could not believe my eyes. I couldn't believe my ears, the way this person was behaving in court. So I'm very, very thankful and very lucky to not have her as my guardian ad litem. And I'm very happy for all the other parents, mainly mothers, who also don't have Amber Ruder as guardian ad litem anymore because she has been removed from her position that she never should have gotten in the first place. So now that this main antagonist is gone from the picture, I am concentrating on fighting, of course, because the fight's not over yet. I have a trial coming up in January. You know, this is 5 months, 6 months away from my last court date. This is how they do it, and this is why it's taking so long, because every time you go to court, your next date is in 2 or 3 months, 2 or 3 months, 2 or 3 months, and this is how a whole year has already accumulated, you know. So my trial is at the end of January, and my point is that there should not even be a trial. None of these people have any jurisdiction because I'm not charged with a crime. There's no criminal charges against me. Therefore, the juvenile court, the Office of Guardian ad litem, they shouldn't even be involved in the first place. So,
right. Just to point out that you've had 3 protective orders filed against you. All 3 of them have been removed because the allegations have been proven false. And the last protective order that was filed against you at yet another very convenient time, the last protective order was expired on September the 30th. So you have no protective orders against you, essentially no standing accusations. So this is no longer a family court issue.
That's right. Even though I technically and legally I'm free to go get my son, I still can't because they say so. I can't go and get him until this whole thing is over. This is how it works. And in January, if they decide to protract it another 6 months or another 6 years, I will still not be able to take my son. So I am working right now on throwing out the case altogether, and because, like I said earlier, the juvenile court has no jurisdiction. And can I give my case number?
Yeah, absolutely.
The case number is 1065414, and it's Beyer versus Zheleva, Beyer. And if anyone would like to write to the new guardian ad litem, please do. I would appreciate that very much. His name is John Moody, and we can let him know that what is really going on, and we can hopefully get some justice out of him, and not the same thing that happened to with Amber Ruder. And John Moody's email is rjohnm@utcourts.gov. I would appreciate that very much. If anyone who wants to contact him, please write to him on my behalf. And
do you have the
more
phone number as well, Katerina?
I don't have it with me right now. I'm sorry.
Well, it's your lucky day. I have it right here. It's 801-344-8516. Again, that's 801-344-8516. And we should point out that John Moody just recently took over from Amber Reuter's position. He is now the guardian ad litem in Katerina's case. So it would be great to contact him and encourage him to act more responsibly than Amber Reuter has done in the past. You could also contact the director of the Office of the Guardian Ad Litem of the state of Utah. That's Mr. Rick Smith. And you can contact him at loriab@email.utcourts.gov. That's loriab@email.utcourts.gov. So we've got some more time left, Katerina. Is there anything else you wanted to say?
I just wanted to basically let people know that this can happen to everybody and anybody. Even though if you're thinking that you're not doing anything wrong, that you're law-abiding citizen, this can happen to you tomorrow by a jilted ex-husband, ex-wife, by a neighbor who has a bone to pick with you. All they have to do is make an anonymous call. They don't have to disclose their name. They don't have to, and anybody can make up any crazy accusations and allegations against parents. So parents should be terrified. It's terrifying what we've allowed this monstrosity of a system to become. It's absolutely terrifying. So if you think this is never going to happen to you, think again, because I never thought that this can happen to me. And here I am. So
right, that's important to point out, is that these claims can be wild and fantastic, and they can have absolutely no basis in reality. But
and they don't, yes.
Right, and essentially I could call on someone I just met and make an anonymous tip and say that this person is, a child molester, and their kids could be taken from them the next day. And this is completely baseless, with absolutely no evidence behind this. And essentially parents all over the country are one phone call away from having their children taken from them for years, if not forever. Of course, unless you're Jerry Sandusky, at which point you can continue to do what you do. You're really abusing children for years and years and years, for decades, and get away with it. Or Jimmy Savile.
Or Jimmy Savile. That's right.
Of course, I guess it helps when you procure children for royalty, but that's neither here nor there at this point. But parents all across the country should be terrified of this, because this could happen to any one of them in any moment. And this is no joke, because they do send the police out to come and take the children, and the police, believe you me, will take children, will do anything they can to follow orders and be the robots that they are and express themselves that way. And in fact, they actually sent police out to take your son when this whole thing first went down, right?
That's right. Yes, with guns. They just came into my house. They barged into my house because they can't come in without a warrant. So basically, what they say is you have to invite them. However, I didn't invite them. They just pushed me basically against the wall and just pushed the door open, put their foot in the door, and just barged into my house as if it's I don't even know what, as if they were looking for Al Qaeda. It was absolutely ridiculous. My son was scared and he was holding me, and they grabbed him. And I looked into those people's eyes, and I asked them, do you think what you're doing is right? And they gave me a canned answer. We're just here to do our job. We're just here to do our job. One of them looked very embarrassed. he wouldn't even look at me. But the other one was there to do his job. So.
Well, we're just doing our job, the famous response of every goon and tyrant in history. That is no excuse. But nevertheless, in the next we have about 10 minutes left here, Katerina. I just wanted to go over where we are, or where you are right now in the trial for the listeners. Because, as you mentioned a second ago, all of the protective orders have lapsed because the accusations were baseless and were found to be baseless.
Mm-hmm.
This is no longer technically a juvenile court or family court matter. This, at most, it's a civil matter between you and your ex-husband.
Mm-hmm.
But there's no reason for you to be away from your son. It's absolutely insane. You have actually filed a motion to terminate jurisdiction over the minor child, right? Could you tell us a little bit of what that is?
Yes, I did file that motion. Basically, I am trying to throw out the case of juvenile court altogether. This is what this motion to terminate their jurisdiction is. And the judge in about a month's time has to rule on my motion. She either has to grant my motion and throw out the case, as she should, and we should encourage the judge to do so. Or she can deny my motion, and then I'm going to go to trial for termination of my parental rights and facing the possibility of losing my son forever. However, I'm not going to give up that easy. There's plenty of other avenues I'm going to pursue, but for right now, I am preparing for the trial in case there is a trial in January. An interesting fact, if I can mention here, neither Amber Ruder nor the other attorney, Jerry Rainier, my ex-husband's attorney, none of them had expressed any interest into summoning expert witnesses to the stand. And when I say expert witnesses, this is the detective, the two detectives, the DCFS investigators, the DCFS workers. No one wants none of these people want to hear what these investigators have to say, even though they're central in the whole story. Isn't that odd, Brandon?
Yeah, it's very odd. I mean, especially these people are actually professionals in this field, right? If the allegations are true, certainly they would be in a position to corroborate that. Of course, they are in a position to be expert witnesses. It appears the reason that actually it's clear the reason that Ruder and Rainier don't want them on the stand is because they would actually destroy Ruder and Rainier's case.
That's
as
right.
they stated over and over again. I read that expert from Dr. Stringham's letter, and I can tell the listeners here that the letters that the letters and emails that I've read from Carly Eccles and Jeff Ellsworth aren't much different. They're quite clear that there's no evidence for abuse here. So
Yet,
I know
sorry.
No, go ahead.
Yet, neither the other attorney nor the guardian ad litem want to hear what these experts have to say. And mind you, both the detective and the DCFS, they're from Special Sex Abuse Unit. They know an abused child when they see one. And they looked at my child 3 times, and 3 times over and over, they did not see a child who was abused, not sexually abused, which is it sounds even more scary, And people take that seriously. Once you throw those kind of allegations, and anybody can accuse anyone else of anything, And unlike our Constitution says, in common law, in juvenile court, you are presumed guilty until you prove yourself innocent. And in my case, even when I prove myself innocent, they keep on hammering. It keeps going.
Right, and they're also unconstitutional because you have yet to stand in front of a jury at a family court, because family courts don't have juries.
That's right.
Even though you have a constitutional right to have a jury trial.
And I have the constitutional right to face my accuser. I was not able to face my accuser for 60 days. Because ex parte protective order is just anonymous. They come and make the allegations, and you just have to wait. You just have to wait to face your accuser.
And they can keep doing it too, as
Nothing prevents them from refiling. Nothing whatsoever. You can refile the next day. It's such a I don't even know what to say. It's such a loophole.
This was the case with your case, actually, is that the protective order came out. It was found baseless, so they filed again. It was found baseless, so they filed again. And this can just go on ad infinitum until the court actually puts a stop to it.
Or until I sue my ex-husband for felony in the court. Not in juvenile court, in regular court, because it's a felony under Utah law to file perjured and bogus child protective orders. It is punishable by up to 5 years in jail upon conviction. So what they're doing is illegal. However you want to look at it, it's completely illegal. And like I said earlier, the child is suffering. He's being separated from me. I am suffering, and the system is just not interested in us as human beings, in our feelings, in our lives. It's all another ATM machine, another case number. We're numbered, just like in Nazi Germany. All I am to them is this number, no more.
Right, and this is all part of a system that was top-down, created in order to separate the family and to make the state the ultimate authority for everyone. So the state, if it separates the family and all of the systems that bind people together, whether it be nationality, tribe, or family,
or
specifically
sex,
family,
men and women, yeah.
Yes, it's completely designed to separate everybody, so that the state, when it speaks to you directly, and there's no one there to stand up for you. And when you have no one there to stand up for you, and you're not connected to anyone else, and you don't have anyone to stand up for, so you go into complete tyranny that way. It would be something to look at, for the listeners to check out the recent constitutional amendment that was passed in Ireland. It was put up for a vote. I feel very, very sorry for the Irish people now. After this law was passed, that essentially gives the government the ultimate authority over the children, based on the UN Rights of the Child Treaty. But this is all part of that system here in the United States, with the CPS system, the DCFS system, the family court system. It's all a means to gain control of the child, of the family. And when you have the society where government can rush in and take control to take your children from you, this is neo-feudalism to the 10th degree. This is something that you read in history books and think that the previous society was savage. How could so many people allow feudal lords to come in and prima nocte and that sort of thing? How could these people allow such things? Well, it's right here. Feudalism never left, because now your governments can come in and take your children for the most baseless claims, and there's no way to get them back. Now, of course, we hope that will not be the case. And in your situation, Katerina, we do seem to have had some victory with getting guardian ad litem amber ruder removed from your case. That is some small silver lining in the whole dark cloud, and hopefully that will benefit some other people who've been involved with her. And
absolutely.
It's largely been because of a lot of listeners and readers who've called in, or I would imagine it is, who've called in to the Office of the Guardian Ad Litem and explained to the supervisors what's actually going on with this person. But the fight isn't over, because you still have a guardian ad litem, and you still have a case with the family court system in Utah. So it's important for all the listeners and all the readers of the articles that we put out about this case to get in contact with the guardian ad litem of your case, Mr. John Moody, and I'll give his information out one more time. You can send him an email at rjohnm@utcourt.gov. That's rjohnm@utcourt.gov. One more time, rjohnm@utcourt.gov. Give him a call at 801-344-8516. Again, that's 801-344-8516. We've only got about 1 or 2 minutes left to go, Katerina. I want to give you the last word here before we have to end the show.
One other thing I'd like to say, if any of your listeners have a similar story, or if they know someone who has a similar story, they can contact me at my email, which is given at the end of your article, and I'll be more than happy to hear from you.
Yeah, do you want to give that email out on the air?
Yes. My email is katia_830@hotmail.com. And thank you very much, and I really, really appreciate your listeners and your readers. It's been actually, it's no small feat what we together have accomplished to remove this guardian ad litem. They are untouchable. I only know of one other case where a guardian ad litem has been successfully removed. It's very, very, very rare. So I really, really appreciate the readers and the listeners. Thank you.
Well, we certainly hope that we're going to push this a little further and get your son back to you where he belongs. Katerina, thanks for coming on the show.
Oh, thank you for having me, Brandon. Thank you.
Yep, and we're going to get the article, the most recent article that I put up over at Access Post. We're going to put that up here on ucy.tv/TT, Truth on the Tracks. And the article is entitled, Katerina Jaleba's 5-year battle to reclaim her son from rogue family court system continues. And we have 2 other articles up on this issue as well that we'll try to get up, so you can check those out. All the relevant information will be there. Again, you can catch us here at Truth on the Tracks every Monday night and Friday night at 9 p.m. Eastern Standard Time here at ucy.tv. This has been Truth on the Tracks. I'm Brandon Turbeville. We'll see you next week.